Thank you again very much for your help. Awesome. Well, welcome everybody. We might still have some folks trickling in, but I am really excited to be here and just spending a little bit of time talking through the Title IX proposed regulations that we got in the last few weeks. So for those of you who don't know me, my name is Bridget Koestner, and I'm the policy manager here at the Alliance. Over the last several years, I've been working with the colleges and universities in Connecticut, our campus partners, our campus advocates throughout the state, on a variety of different things, one of them being Title IX. So I'm really eager to have this conversation today because as I was sharing, as some of you were filtering on, it's good to have some good news in the world right now, and these proposed rules are a piece of good news for you all. So I hope that that's a good way to start your Friday morning here. Additionally, for those of you who may be new to the Alliance, I am here with the Connecticut Alliance to End Sexual Violence, and we are the statewide anti-sexual violence coalition. Just to provide a quick preface to today's program, so we're going to be talking about sex-based discrimination and the ways that this Title IX regulation would apply to sex-based discrimination. Now, this is including not only sexual violence, but also domestic violence, dating violence, stalking, LGBTQ plus discrimination, pregnancy discrimination. So my primary focus through the program is really going to be on sexual violence because that's, essentially what our agency primarily does. However, I do want it to be known from the start that we are going to be talking about these other topics and that these regulations would apply to those other topics. I also want to preface it by sharing that I will be kind of focusing on higher ed examples, higher ed application. However, it is important to acknowledge as well that the vast majority of these regulations would apply as well to K through 12 schools. We'll have a Q&A after the program today, so definitely feel free to stick around and ask some questions. Make sure to take care of yourselves. We will be talking about campus sexual violence and sexual violence in general, things like LGBTQ plus discrimination. So just ensure that you check in, see how you're feeling. If you need to pop off, we are recording today's session, so you can definitely revisit it later. And so with that, I am excited to get started in talking through this topic a bit. So just a brief overview of, how we got here. In 2017, there had been Obama-era guidance that was rescinded by the Trump administration. So there had been equitable guidance that was, addressing sexual misconduct that came right from the White House while Obama was in office. However, the guidance was rescinded pending formal regulations from the Trump administration because they felt that the guidance had essentially provided too many rights to survivors in a way that was unfair to the accused. There wasn't necessarily much evidence to support that, or any evidence necessarily other than many conversations that the administration, primarily Betsy DeVos, had with those who had been accused of sexual violence on campus. So we were definitely concerned when that was rescinded, and even more concerned in 2018 when the Trump and DeVos era rules were proposed. So this did differ from guidance because while guidance essentially provided a roadmap as to how people could be, within the bounds of what the Office on Civil Rights would essentially deem compliance, with Title IX. To have a regulation definitely gave it, there was more of a significant push to really follow these regulations as they were written, which was problematic because these rules were extremely controversial, and they really seemed to limit the requirements that institutions would have to respond to sexual violence, as well as some of the supports that they would be able to provide to survivors. We'll talk through a little bit about those things today, but for instance, things like off-campus incidents of sexual violence were no longer covered under Title IX. The threshold for definition of sexual harassment was very, very high and often unattainable. So the comment period had begun, so the public had an opportunity to respond to the regulations, and there were actually approximately, it was 120,000 comments in response to the proposed rule, which was a very unprecedented response, but it was due to their harmful nature. Most of these comments were not in support of the regulations. So once they sifted through those comments, some of it was taken into account, the vast majority of it was not. And in 2020, at the beginning of the COVID pandemic, that May, despite everything that was going on in the world, the administration did release their final rule. Again, very similar to what they had proposed. It was officially implemented in August of that year. And then in 2021, upon Biden's presidency, he did order the review of that regulation. And the new administration also released a Q&A document to talk through where survivors still had rights and could still be supported under the 2020 regulations, and to provide that clarity. So we actually just recently hit the 50th anniversary of Title IX in June, and in honor of that anniversary, a proposed rule based on the review was released in June of this year. However, unfortunately, this got buried in the news cycle rather easily, given that it was the day before Roe versus Wade was overturned that we got this new rule. So I think this is something that would have ordinarily been more on folks' radar. This is something that would have been in the news more. However, obviously, what happened was so monumental and unprecedented, given the overturn of Roe v. Wade, that that was really the primary focus that weekend. But this is a really significant, proposed regulation and a significant move by the administration. These rules would restore vital protections from sex-based harassment on our nation's higher campuses and K through 12 schools. It would also strengthen and protect all the rights of all students, including LGBTQ plus students who were essentially in many ways left out of the previous administration's Title IX guidance. It also reduces this idea of exceptionalism that we saw in the Trump rules, the Trump era rules. Essentially, there were all of these high thresholds and high standards for cases involving sexual harassment that would essentially suggest that this is something that people falsely report on a frequent basis, and that survivors of these particular instances are to be less believed than victims and survivors of other crimes. Of course, this is problematic. We know as advocates that that is not the case, that there is not truly this exceptionalism where there would be more false reports or anything of that nature. And of course, we believe and support survivors. So we're really glad to see the proposed regulations taking this direction. I will also, again, clarify for folks that might not be familiar with this process that these are proposed rules, so they are not yet in place. However, if they are to eventually be published as written, it would be able to provide this strengthening and protections. So one really critical kind of piece of these regulations is the way that it would prohibit all forms of sex discrimination. So this would include discrimination based on sex stereotypes and characteristics. It would base discrimination against individuals who are pregnant and have related conditions. Things like ensuring that there were reasonable modifications to ensure individuals who are pregnant, breastfeeding, have recently given birth can continue to access their education. Things like having a safe and clean lactation space that isn't a bathroom available for them, allowing individuals who are pregnant to take a voluntary leave of absence. So these supportive measures would need to be in place for individuals who are pregnant and have recently been through childbirth. Sexual orientation and gender identity would also be protected under this. Institutions would not be able to treat LGBTQ plus individuals in a way that would subject them to more than minimal harm by treating them any differently. And they must allow them to participate in a program or activity at the institution that is consistent with their gender identity, which is really, really critical given some of the discrimination we've seen throughout the country at this time. Something to note, however, and we'll touch on this later, but that doesn't necessarily apply to athletics. Again, that's something that we'll circle around to later. So it would also create a new definition of sexual harassment. So under the 2020 rules, there was this definition, again, that had a really high threshold as to what would be defined as sexual harassment. And that's written here for your reference. But essentially, it was required that there was a significant level of severity. And the way that this language has really been interpreted, it typically required the victim to be effectively denied their education to prove something has already been lost. So because, it says effectively denied in there, the student, who experienced that sexual violence was in a position where they really needed to show that they were already starting to fail classes. They were already not going to classes, rather than have that support up front to avoid those outcomes. So in response to that harmful definition in the 2022 proposed rules, we see a definition that is more attainable and less harmful. This would be a return to a longstanding precedent of utilizing this kind of hostile environment definition that was in the Obama era guidance, and would be appropriate in these cases. It creates more space for the context of a victim's experience because they're evaluating the totality of the circumstances, and they're evaluating it subjectively and objectively. So they're considering what that particular victim's experience is and how they are feeling, rather than attempting to have applied this, sort of objective nature to their evaluation that really doesn't take into account potentially the victim's needs. It also doesn't require that effective denial, or, as this proposed rule states, it would deny or limit a person's ability to participate. So, they wouldn't need to be fully denied. It could also be limited, right? So there's more room there, but also they would not need to necessarily demonstrate the same level of harm or impact that they currently do in order to fall under the definition of sexual harassment. Additionally, one of the major provisions of the 2020 rules that was really problematic is that it only required institutions to address incidents that took place in an education program or activity in the United States. So this excludes off-campus spaces where the institution didn't have what is called substantial control. So essentially that they owned that building, right? Or it was a space where they essentially could control what was going on inside. It was with university affiliated organization, and they had some say. And it also excluded study abroad programs because those individuals were not in the United States was the reasoning there. However, the 2022 proposed rules would continue protections for on-campus incidents of sexual violence, of course, but also restore protections for these off-campus incidents. So if there are any off-campus houses, that students are dwelling in, right, and other spaces that they may congregate. It would also expand Title IX protections to study abroad programs when those students or employees of the institution are studying abroad. This is in recognition that these off-campus incidents often inevitably impact the victim's ability to participate in the educational program or activity. If they're at a party over the weekend, in a home that some individuals that they go to school with are renting, and they experience sexual violence from one of those individuals, this is somebody that they may have to go to class with, or may even be instructed by in class, right? So of course, this is going to impact the way they move through their education. And so it's really critical that that's addressed. And so we're really glad to see that brought back in these proposed rules. It also really recognizes the obligation that institutions have to keep their campus safe for all, that even if an incident doesn't take place on campus, that there's now this person that is experiencing the ramifications of this harm, and there is somebody that perpetrated this harm that may need to be held accountable in their community, right, in order to prevent future harm. So it definitely sort of recognizes this obligation that institutions have. Retaliation is also a topic that's covered in the 2022 proposed rules. It was covered in the 2020 rules as well. However, it was not defined. They speak to retaliation, but don't actually talk about what it looks like. However, it is prohibited in the 2020 rules. However, in the 2022 rules, this would be clearly defined. And institutions would be prohibited from taking retaliatory action against a victim, essentially weaponizing their own code of conduct. So a student maybe who experienced sexual violence and they were drinking or using drugs. If the institution threatened to penalize that student for underage drinking under their code of conduct when they came forward to report that sexual violence, based on the department's proposed rules and their definition, that would be prohibited explicitly. This actually marries well with Connecticut state law, where we clearly defined in our 2021 legislation that institutions must provide amnesty to students who are using drugs or alcohol and make a report in good faith. So this would essentially continue to sort of back that amnesty provision, and they would complement each other rather nicely. It also very importantly defines and prohibits peer retaliation. So if individuals at the institution, who are not necessarily the perpetrator or the institution itself, are retaliating against the survivor for coming forward, they would have recourse under Title IX and be able to seek support there. This is really critically important because the sort of retaliation often denies a survivor access to a program or activity. The person who harmed them may very well be removed from their class, removed from the campus, and then that survivor is in a position where they're experiencing backlash from their peers who may have sided with that person, right? And so essentially there's still a hostile environment that's in place that the institution would have an obligation to remedy. There are a lot of ways that these new regulations would ensure institutional awareness in response to sex-based misconduct. So it would require investigation of all complaints even without a formal report. So at this time, institutions launch their investigation when this formal report is filed. However, we've seen this to be problematic because it's sort of been a hoop that survivors have to jump through. Many of them don't understand that there is this official form that they need to sign in order for the institution to launch their investigation. So it would drop that requirement and therefore create a more accessible process that is less confusing and less intimidating, right? Having to sign a sheet like that is something that survivors may find to be intimidating to them. It also essentially puts the burden where it should be, right? The burden should be with the institution to be compliant with Title IX and to be examining, investigating, addressing sexual violence on their campus, rather than the responsibility of survivors consistently having to advocate for themselves through a process that they might not know anything about. They can also offer, the institution can also offer formal resolution without a formal report. So right now, in order to go through with an informal resolution, whether that be a variety of supportive measures that the institution might offer or a restorative justice practice, they need to, again, fill out that formal report, which keeps some individuals from accessing some of that sort of report. The department also said that this must be voluntary. So if individuals are going to participate in an informal resolution, again, they don't need to go through that formal report, and they also can't be coerced by the institution into participating in that over, over a formal hearing that in general, right, if they aren't seeking any sort of remedy and the situation is being investigated. So this is definitely also something that will ultimately, I hope would help students feel reported and help to avoid retaliation, because sometimes, of course, many of you advocates may know victims will be blamed because they reported, but if the institution is required to investigate and, the onus is on them to kind of pursue this, then ideally survivors will be in a position where they'll experience less retaliation. They also brought in the pool of responsible employees. So those are employees who are responsible for alerting the institution, alerting Title IX if there is an instance of sexual violence that comes to their attention that would need to be addressed. So at this point, they really narrowed in the 2020 regulations what employees were considered to be responsible under this. However, it would be expanded to ensure that the institution does become aware of what's going on their campus and has the opportunity to investigate and offer support. So ultimately, this is something that is good and will hopefully create more access to this process and create a more supportive environment on campus. Some survivors will report to a professor or other employee thinking that, they'll be connected to help, and then they aren't. And now they would be. So that's something that we were glad to see, that broadening, especially because confidential, employees, those who maybe are with the counseling center, are an advocate, not want it to be report. The new rule did in the 2020 regs, and hopefully dropping this would make the process again more accessible and clear. The actual knowledge standard was a high standard, really, to determine whether or not the institution was aware and responsible to respond to sexual violence. Institutions are, again, required to monitor and prevent, but that would be included explicitly in the 2022 rules, that it is indeed their responsibility to monitor and prevent it. It is not in the victim's hands, it's in the institutions, right? So again, it puts the responsibility where it should lie, rather than making it the victim's responsibility to ensure that the right people at the institution know, and they know in this formal manner. It also would create a provision where former students and employees would be able to file a report, which is not currently an option under the 2020 regs. And this is important because it creates a safer campus if there's still an active perpetrator that's doing harm on that campus, right? It may also make the campus a safe place for that individual to return to or visit in the future. And it may give them that sense of closure or justice that they may feel as if they were denied by not being able to pursue a report. So this could be somebody who recently graduated, right, and didn't get a chance to report before graduation. This could be someone that didn't feel safe reporting until they were removed from the environment, who were experiencing mental health effects that were so significant that they couldn't continue their education. So this would provide all of those individuals with an important route to recourse. There would also be some changing to the way that hearings are done in a way that would be less harmful to survivors. Say somebody does pursue, one of these more formal hearings after reporting to the institution. the live hearing requirement that is currently in place under the 2020 regs would be removed. So institutions could have a hearing process without that sort of level of formality, stress, and even the trauma that a survivor can incur by having to attend a live hearing for this issue at their institution. It also would not require cross-examination, which was something that we were happy to see, given that hearings under the 2020 regs do require cross-examination to occur. Now, it's also important to acknowledge that if there is somebody that does not submit to cross-examination, one of the parties or a witness, it cannot be seen as evidence of their guilt if they decide not to pursue, if they decide not to be cross-examined, essentially. And additionally, the evidence that they presented earlier now can no longer be exempted. This was the case under the 2020 regs. However, there was a federal case that created a standard and found it was unconstitutional for it to be the fact that, the evidence that they presented would then not be able to be included. So the Department of Ed did release a memo along with the Q&A that they had released that I spoke to earlier. And that memo spoke to the fact that this evidence cannot be exempted. So it's important to consider the rights that somebody still has if the institution does require cross-examination, because ultimately cross-examination is still permissible under an institution's policy. It's just not mandated by Title IX. And then lastly, but importantly, the preponderance of the evidence standard is set in the 2022 proposed regs, the standard that should be used. This is a more equitable standard than the alternative, which is clear and convincing, which was an option under the 2020 regs. And this actually would still be an option for institutions. But if they were to choose that standard, then that would need to apply to all discrimination cases if they did decide to go with it. Again, sort of removing that exceptionalism that sexual violence is sometimes given by individuals that don't understand myths around false reporting and believe different victim blaming and shaming beliefs. It's also important to note that the preponderance of evidence standard is in our Connecticut state law as the standard that needs to be utilized in these cases. So we're in a really great position here that will consistently, continue to be the standard. So we're glad that the federal, regulations that have been proposed would sort of, align with out here in the state. So that's a lot. There are a lot of really good things here, as I said, a lot of ways that survivors would have their rights restored, a lot of ways that would continue to hold institutions accountable for protecting students and individuals who perpetrate sexual violence responsible on their campuses. So what's next? What does this look like? Ultimately, the federal government will open a 60-day comment period where the public will have an opportunity to weigh in about these regulations as they've been proposed. So they can be in favor of aspects and in opposition of aspects, and will sort of speak to, from their expertise and from their standpoint, what their interests and concerns are about what has been proposed. There are some concerns at this time that I've heard from national groups and folks sort of speaking to. One is that the religious exemption piece in the 2020 regs was not addressed. So under the Obama era guidance, if somebody wanted to claim a religious exemption from some aspect of Title IX, and state that what was being asked of them really did not align with tenet of a religion that the institution is sort of built around, that they would have to submit for an exemption, put in some paperwork, right, that would show that they are exempt from this, so that if there's a complaint in the future, that exemption can be referred to. However, under the Trump DeVos era rules, this was not the case, and instead the religious exemption can be claimed at any time. So if somebody is discriminated by their institution, experiences that sort of discrimination, the institution can say, well, this was a religious exemption that we want to claim. So of course, this kept there from being a certain level of accountability at these institutions. And also there's this lack of notice and understanding from students, right? They would not understand that the institution was exempt because they had not claimed it previously. So despite the way that this rule is problematic in that sense, this has not been suggested to have been rolled back in the proposed regs. So I know that's something that some national groups are seeking to address. Additionally, individuals who have sifted through this, it is a 700-page document, have said that there needs to be a bit more defining around what is a restrictive versus a disciplinary measure. Because these are two different types of measures when it comes to how perhaps somebody who's accused is able to access things on campus. And so providing further guidance to ensure that institutions are aligned with the proper measures that they can take at different stages and based on different outcomes, is something that that these institutions and groups are seeking. So once that comment period closes, these concerns, these comments, will be reviewed until the time where a final regulation is released and ultimately implemented. The Trump DeVos era rules are going to continue to be in place and continue to be the law of the land, which is important to remember. However, it is also important to remember that there is that Q&A document that folks can refer to if they are going to, be going through this process, if they have any questions about their rights, to ensure that they are doing and advocates are doing all that they can to provide support to survivors through this process. Ultimately, the final regulation would, again, be announced, released, published to the Federal Register, and then have a date set for implementation. The timeline at this point, though, is unknown because it's really going to be primarily based on the comments that we see. How many comments are there? How many changes to the regulations are being suggested? Are these seen to be controversial in nature? Essentially, how much review needs to be done and potential edits need to be done before that release. So we won't have really a sense of this until that comment period closes. And even then, we won't know for sure. We were not for sure about the DeVos era rules, and we're hoping that they wouldn't have been released during the beginning of the pandemic there in the way that they were. So we might not know what to expect and when. And then the department also shared that within the documents that they released to sort of announce these proposed regs, that there will be a separate rulemaking regarding male and female athletic team participation. So essentially, if individuals in a team that aligns with their gender identity rather than the sex that they were assigned at birth. Again, this is an issue that we've been seeing throughout the country right now, where individuals are being barred from athletic programs because they are trans, because of their gender identity, which is something that's deeply problematic. And so I'm interested to see what the department ultimately proposes and releases about those situations. So, as I said, I did want to open it up for a Q&A. Thank you for listening to me speak for about 35 minutes straight about Title IX, although for some of you, I'm sure this is not the first time that you've heard that. However, if this is your first time hearing me talk about that and you'd like to keep in touch or have any questions you'd like to send over via email, whatever the case may be, my name again is Bridget Koestner, she, her pronouns. I am the policy manager here at the Alliance. And you can reach me at bridget@endsexualviolencect.org. So I'm, always happy to talk through anything Title IX, provide support through, for advocates and individuals who are going through these processes. So please feel free to reach out anytime, and I'm happy to provide any technical assistance that I can. So with that, I'm going to stop my share and sort of open up the conversation today. So feel free to raise your hand. If you have any questions, unmute yourself. We can enable the chat here. I see that was disabled, so I will enable the chat so you can speak there if you have any questions. But I'm eager to hear any thoughts that you may have. I just threw a lot of information at you. So feel free to jump in. Anything?
Yeah, what is the potential timeline on this? Like, when are comments closing? I mean, I know
So-
it's hard to pin it down, but
Yeah, no, I appreciate that. So actually the comment period has not yet opened. And once the comment period opens, the public will have 60 days to respond. So the comment period is likely to open soon. They're really just giving folks an opportunity to, again, review the 700-page document and speak to what details of it they're concerned about. And then, once they open up that time frame, it'll be those 60 days. So it is a little murky. We're not totally sure, but we know that much at least. Question about retaliation. Is retaliation from peers prohibited against both the victim and the perpetrator? That's a good question, and I would want to look at the language more specifically to see how that's defined. However, typically under Title IX and the way that this is framed, so many of these provisions and rights are really equitable. So based on the way Title IX is applied, I would imagine that the retaliation is considered for both parties. However, it would need to fit that definition, of peer retaliation in order for there to be that, in order for there to be that sort of recourse that may be necessary. But that's something that's important to acknowledge, is that Title IX is something that's very equitable. So there are a lot of rights that accused students have. And the issue is that it was something that was really misperceived by the previous administration. And that's why they sort of tipped the scales away from survivors in a way that made individuals that, were accused, had less responsibility and accountability, and same with the institutions. All right, is there anything available we can give to clients about this, info packets or websites? Absolutely. So I will be working through some information of my own that I can provide. However, there is a really excellent resource from the National Women's Center that I actually have up here right now, and I'd be happy to put in the chat. They always put out really great information when it comes to Title IX in a way that's really accessible to individuals that it might impact. So it talks through the major provisions and changes that we're anticipating. So I definitely recommend that resource for the time being. And I am hoping to put something together that's a little more concise. Might the Alliance sign on to any of the public comments? It's something we haven't necessarily discussed yet. We'll have to see what those public comments look like and what we might align with. But if individuals, I see another question about individuals writing comments. If individuals are taking that route, I'd be more than happy to provide support in that and, share whatever resources and information that I can. As you may see in the chat, my colleague Amanda did pop the evaluation into our chat there, so feel free to click on that now, or as you're exiting today, somebody else had said, okay, so yeah, it seems like there would be support for, it would, be good for there to be some support around, writing or signing on to comment. So I would definitely, again, be glad to connect with folks who are interested in submitting comments and see how I can provide support. Yep, again, there's that evaluation there in the chat. Any other questions? All right. Well, not seeing any at this time. This is something that I do want to share. I'm going to continue to be talking about, keeping folks in the loop about. So ultimately, I would be glad to host sessions like this in the future. If that's something that would be helpful, just a quick informative little session. I'm here enjoying my coffee. I hope that you're home, comfortable in your office, wherever you may be, sort of doing the same, and just kind of relaxing and getting some info. And again, thankfully, a piece of good news. But I definitely would be glad to continue to provide information in this format or any others that you may find to be the most helpful or accessible. So please feel free to provide feedback in that form that Amanda had put in the chat, or to me directly about formats that would be helpful for future info. But I'm definitely happy to keep folks updated and apprised as to what happens next. And hopefully, this process will, move quicker than the previous administration's process did. Because it's definitely a less harmful one. All right, I don't see any further questions. So with that, I can end the recording. Thank you, Amanda. My colleague Amanda is ending the recording. I also will be the last on here. So if anybody did want to stick around for questions, comments, concerns, to speak to me one-on-one, I will be the last one in the room. So thank you all so much for attending, for asking questions, for taking the time to learn about something that is hopefully really going to be of support to those that you support in your roles. Thank you for the advocacy that you do. It makes an incredible difference in the world and on college and university campuses. And every day that I do this work, every day that I dig into Title IX, I am abundantly thankful for the support you support you provide to survivors. So thank you for that. And thank you again for, you could have chosen to spend this little hour anywhere, and you chose to spend it with me talking through Title IX. So have a good one, folks. And again, I'll be the last one here.